Welcome to this lecture on the cross-border rules for national insurance, so social security. This is where workers would be seconded, for example, to France for 3 months, say, and then come back. We're going to look at the NI rules, national insurance rules, what they were before the end of December 2020 and what they are after the end of December 20. My name's Dean Wootton. So general principles first. Most countries have a social security system. We call it national insurance. Other countries may call it something different. Now, most countries link their social security contributions to welfare benefits, but not all of them. Some of them is just effectively an extra tax. Now, for mobile workers, those that are seconded to different member states, for argument's sake, where are the social security contributions paid? Is it in the host country, i.e. where the work is carried out? Or is it in the home system, i.e. where they live? Or is it in both? Or is it in neither? So let's look at the default position. Now, you generally pay contributions where the work is performed. However, where an employee is working abroad for a temporary period, then they'll pay NI, or social security contributions, in the home country only. So that might be when you're temporarily seconded to a different country, say. Now, the income tax rules are irrelevant. So you could quite easily pay income tax in one country and national insurance in another. Now, we're going to look at the world in 3 zones for this purpose, Zone 1, 2 and 3. Now, Zone 1 is the European Economic Area, which is EU member states plus Norway, plus Iceland, plus Liechtenstein, and add Switzerland into that. So that's Zone 1. Zone 2 would be non-EEA countries with reciprocal social security agreements with the UK. So, for example, the US, Canada, Japan, etc. We've also got Zone 3, which is the rest of the world. So no reciprocal social security agreements with China, Australia, India, for example. And we'll consider these zones one by one. Now we'll look at Zone 3 first. Now this is non-reciprocal countries. Now, contributions are generally paid in the host country, i.e. where the worker's working. Now, if you get seconded to, say, India for a period of time, then you could pay voluntary national insurance in the UK to preserve entitlement to benefits. But there are some situations where home country national insurance contributions continue for 52 weeks. And on the 53rd week, you then start paying host country contributions. Now, to get this 52-week relaxation, you've got to be a UK-established business with an ordinary UK resident employee. So if a UK company was seconding somebody to, let's say, India temporarily for, let's say, 3 months, then for those 3 months, we would have UK social security contributions due, providing we've got a UK-established business and the individual is ordinarily UK resident. So short-term secondments, that would cover the 52-week rule. Now, the Zone 3 rules are unchanged post-Brexit, as you would expect. Moving on to Zone 2. So Zone 2, we have reciprocal countries. Now, the liability is determined by specific bilateral agreements with that particular country. So, for example, a UK company sends an employee to work in the US. They will remain, the individual will remain in the UK system for 5 years. There's no US social security contributions at all. The individual will pay income tax in the US, but national insurance in the UK. The UK employer would need to apply for a certificate of continuing liability. Now, these reciprocal rules only apply if the employee is posted abroad. They don't apply if an employee gives notice to their UK employer and then goes and works in the US. This would be an example where these rules would apply. If, let's say, for example, I had a UK accountancy firm and on a newly qualified member of staff qualifying, they would send them to the US for a 2-year posting or a 3-year posting. So that's what this is looking at. Now, Zone 2 is also unchanged post-Brexit. Well, let's look at Zone 1. Now, remember, Zone 1 is the European Economic Area, i.e. EU member states, plus Norway, plus Iceland, plus Liechtenstein, and Switzerland joined from 2012-ish. So it's our relationship with those countries. Now, the UK EU Social Security regulations applied up until the end of December 2020. Now, under these rules, a detached worker on an assignment and not expecting to exceed 2 years remained in the home country scheme. So in the UK scheme, if they're a UK individual, for example. And the employer had to obtain a coverage certificate, which was A1 in the UK. Now, this covered postings up to 5 years. So that was postings up to 2 years. Now, if the postings were longer than that, you could remain in the home scheme if the authorities agreed. Otherwise, you were paid where the work was carried out. So there's a general 2-year rule when UK employees were posted to, let's say, France or Germany for a year or 18 months or 2 years, say. Then they paid national insurance in the UK, effectively. The employer obtained the A1 certificate, and that was pretty much it. They came back to the UK after that 18-month posting, say. So what is the impact of Brexit? Well, Zone 2 and 3 remain unchanged. It's just not Zone 1. What changes for Zone 1? Now, there's a long time when we thought we were going to get a no deal. And if we did get a no deal, then we were going to be Zone 2 if we had individual reciprocal agreements, Zone 3 if not. Now, because of that looming overhead for quite some time, there was a UK-Ireland bilateral agreement in 2019. We said postings up to 2 years, workers would pay contributions in the home country only. And that mirrored the existing Zone 1 arrangements. Now, we have a post-Brexit deal, of course. Now, the UK-EU Trade and Cooperation Agreement was agreed, Christmas Eve? And it's a protocol on social security coordination between countries. Now, the rules for detached workers apply broadly as they did before. So postings up to 2 years remain in the home country scheme, but the change is there's no possibility of an extension. Remember, if you were staying for, let's say, 4 years, if the countries agreed, you could get the home country scheme applying longer than 2 years. There's no possibility of that under the UK-EU Trade and Cooperation Agreement. So you would start paying local contributions if the stay was for more than 2 years. So that's the change. Now, this isn't 100% agreed, not yet at the time of recording this lecture, because there's an opting out provision. Now, each EU state can opt out of the detached worker rules. Now, each country must individually agree to apply the new rules by the 1st of February 2021. Now, most member states are expected to opt in, and quite a few have already by the time of recording this lecture. Now, failure to opt in is effectively opting out. So if you don't opt in, you are opted out. And if you don't opt in, then you'll be Zone 2 or Zone 3. So we have a post-Brexit deal, which effectively is nearly the same as the one we had before Brexit, but it's that you can't extend beyond the 2 years as you could before. So each member state will have to decide, are we going to opt in to this UK-EU Trade and Cooperation Agreement for national insurance purposes, or will we opt out and adopt the Zone 2 or Zone 3 rules? I say they've got until the end of January to decide. Now, the new rules under this UK-EU agreement do not cover Norway, Iceland, Liechtenstein, Gibraltar and Switzerland. Now, special rules apply to each of those countries, and details are in the notes. For example, Switzerland and Gibraltar. Employees will remain within their home country legislation for temporary posting up to 2 years. So that's fundamentally the same. Norway. Employees will remain within their home country legislation for temporary posting up to 3 years. So each of these countries will have separate agreements with the UK for social security purposes. And as I say, full details are in the notes. So what are the employer responsibilities? Well, employees need a certificate of coverage to carry on paying contributions in their home country only. Now, this would be the old A1 or its replacement. At the time of recording this lecture, it's not clear whether they're going to carry on with the A1 or they're going to have a new form. But the principle will be the same. You're effectively getting the certificate saying, I'm paying national insurance in the UK, say. Now, without that, then host country contributions will be due, i.e. where you're working. So UK companies sending their staff to the EU need to know the rules. They need to know the UK rules and obviously where they're going. We should still have this pay national insurance in the UK if it's, say, a 12-month posting or an 18-month posting. That fundamentally stays the same. Now, what about workers that were working abroad before the end of January 21? Now, workers on EU EEA postings before the 1st of January 21 are covered by a transitional arrangement within the EU withdrawal agreement. Effectively, they banked the old treatment, irrespective of whether countries opt in or out. They banked it for the time being. So the existing A1 certificate will carry on. So contributions payable in the home country only. Well, that concludes this lecture on the Social Security rules when UK businesses, in the main, second staff to work in their German office or their French office, etc. My name's Dean Wootton. Thank you for listening.